Joey, are you sure? Are you okay? Okay. All right, let's go on the record now. First of all, good morning, everyone. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Higgs, and Ms. Spengler, and the people are represented by Mr. Orman and Ms. Pearson and Ms. Stitch McGuire. We are outside the presence of the jury. We're outside the presence of all the jurors. There's a request from the jury, and I'll have my staff give you a copy in just a moment, but on the top it says hours of jury, 8:15 to 4:30. So apparently those are the hours that they're going to be keeping. And then it says we request a whiteboard, and then it is signed by the foreperson. I have marked it as deliberations question number 1. I have indicated the case number and today's date. If you would please give each party their copy of the request. Is there any objection from the people?
No, of course not, Your Honor.
Any objection from the defense to me sending back a whiteboard with markers and an eraser?
No, Your Honor.
Okay, we will do that. There is also a request, although it is an oral request from the alternate jurors. They're wanting to know if it's okay for them to have access to a fax machine, and if it's possible for them to have access to a fax machine. Apparently, one of them, or perhaps more than one of them, is doing work or trying to do some work while they're waiting. I don't know whether we can have a fax machine brought out to them. We might be able to do that, but I wanted to ask the attorneys first if they had any position on that. It is an oral request. They just asked one of the staff members whether that was something that we could accommodate. Do the people have a position on that?
Moment, Your Honor.
Yes.
I think we can trust them to send and receive faxes with an admonishment not to send or receive anything with relation to the case. I mean, they can go do a fax at home, and we can trust them not to do it. So I don't have a problem with the alternate jurors having that ability.
All right. Does the defense have a position on that?
Judge, I don't, which begs the question, do they have their cell phones when they're, I'm assuming they do.
They do.
So they can make calls, they can send emails, they could, so yeah, I don't think there's really a distinction there. I don't have an objection to that.
Okay. All right. We'll see what we can do about that without objection from the parties. If it's possible for us to have a fax machine brought to them, we will do that. They know my admonishments, and in fact, there is a blow-up of my admonishments in the room to remind them about them. Ms. Nelson, I know that you wanted to make a record with respect to jurors' access to videotaped evidence, and I wanted to let the parties know, I may have mentioned this before, but in case I didn't, I am not sending back any equipment that would allow the jurors to play videotaped evidence. And if there is ever a request from the jury for equipment to be able to play videotaped evidence, I would call you in first, and we would discuss it on the record just the way we did with respect to this request about a whiteboard. This is the procedure we're going to follow. Anytime there's a request of any kind or any question, I'm going to bring you in, and we're going to have a discussion first on the record, and then we'll proceed. Okay? So does that take care of the concern?
It does, Your Honor, and just so the court is aware, as I'm sure you probably are, I was thinking about the case law last night about unfettered access, particularly to videotaped, and I would ask actually that this request apply as well to any audio tapes. But the case law that I was thinking of was DeBella versus People, D-E-B-E-L-L-A. That's 233 P. 3rd 664, a 2010 case from the Colorado Supreme Court, as well as People versus Jefferson, which is a recent case from the Court of Appeals from 2014. So yes, we would very much appreciate and would ask that the court notify us if the jurors are going to be requesting any access to videotapes. evidence.
And my comments apply not only to videotaped evidence, but also audio taped evidence. So any audios, any CDs, any DVDs, they don't have any electronic equipment in the jury room right now. We're not sending any such equipment. And if they request any such equipment, I will bring you in first and we'll have a discussion. So,
Thank you, Your Honor.
okay, all right. And I'm familiar with the case law, by the way, so. Mr. Orman?
Couple of things, Your Honor. You had asked regarding the penalty phase jury instructions that we had submitted, and I've spoken with Mr. Edwards, who is a special deputy appointed on this case, who's been helping me with these things. And these were sort of cobbled from previous instructions in other cases and instructions that had been presented to the court in other cases. I asked him if he had a set of jury instructions that had been through all the way up to the Supreme Court, so that the court could see what a set of jury instructions at the Supreme Court. There was no reversal on a death sentence in Colorado. The most recent case that I'm aware of that has gone up through the Colorado Supreme Court is Dunlap. I have the instructions from Dunlap. I have both the instructions that were tendered and rejected and the ultimate instructions that the judge gave in that case. I don't have it in a Word format. I have it in a PDF, and I can either give a printout of it to the court or a disc, or I can just email it to the court and counsel if the court would prefer that. And that would be my preference.
What was the date on those instructions, do you know?
March, I'm just looking, hang on, Your Honor. The first page has a file stamp on it of March 6, 1996. And I'm just going to, those are the tendered and rejected, which are the first part of this file. The actual jury instructions that were given by the judge look like they were filed March 7th, 1996.
Okay. I don't know how helpful those will be, but I appreciate you doing that. Does the defense have a position as to an objection as to the people, whether the people can submit those instructions? They're from 20 years ago, so I don't know. I don't know how much the law has changed in 20 years, and I don't know how helpful they'll be, but do you have a position?
I agree with the court that they may not be particularly helpful given how old they are. I actually wanted to make sure that I do have leave of court to submit or to tender in written form file any penalty instructions that the defense wishes to submit as soon as we can get those together, Your Honor.
Yes, you do. I think I had indicated before that you could do that. Yeah.
I thought so, but I wanted to make sure. And just so the court knows, if this works for the court, I was thinking that I know that the court also was interested in knowing what our position was on the instructions that had been submitted by the prosecution. So I'm hoping to do both for the court, submit our tendered instructions and then perhaps provide some red lines and comments and written objections to the people's submitted instructions, if that would be helpful to kind of frame the issues for the court. And if it's okay with the court, I could even submit them. I mean, there are going to be multiple sets of these, of course, because we've got 3 different phases. And so if I can submit phase 1 and then phase 2 and phase 3, depending on, how quickly I can get them done, I was thinking that might make some sense, if that's okay with you.
That's okay with me. I don't want you to file a brief. I'd rather have you make oral argument, but if you want to file a red line version, you can, and then we can take up oral argument after that. If we get to that point, I mean, and this is all just, us speculating on, all of this is moot if there's not a guilty verdict on a first-degree murder charge.
Of course, Your Honor, yes.
But you have leave to file.
Thank you.
Your tender instructions, the people file there, so you have leave to file yours, and if you want to file a red line version of the people's instructions, you can.
Just so I'm clear, and I wasn't intending to file a brief, but what I thought it might be helpful to explain my red lines in maybe a brief paragraph under each instruction.
That would be helpful.
Or stating, we don't have a problem with this, or we agree with this, but we don't agree with that kind of thing. So not like a written pleading like a brief, but just an explanation of our objections and our redlining and our edits and stuff.
That would be helpful. Just a brief explanation, and if you want to cite a case that you think supports your position, you can do that, but just something brief, and then I'll let you make full argument orally later, okay?
That sounds good.
All
Thank
right.
you, Your Honor.
Okay. So, Mr. Orman, you can file those instructions. I appreciate you doing that, and then I'll take a look at them, and then I'll see how helpful they are.
Is it okay if I just send an email to
Your Honor's clerk into the defense and just submit it that way
Yes,
as a PDF attachment?
that's fine.
And can I approach with one of defense counsel? I just have a request regarding this request from the jury.
Yep. All right, is there anything else?
No, Your Honor, thank you.
Anything else from the defense?
Yes, Your Honor. We were preparing to file something in writing with regard to our request under Rule 16, but I think that since I'm here, it's easier for me just to do it orally, if that's okay with the court.
You said Rule 16, did you mean Rule 15?
Did I say 16? Yes, I meant 15.
Actually, it's not. I would rather not have discussions about penalty phase while the jury's deliberating. So if you want to file something, I'll let you file something. I also want to get the whiteboard back to the jury as soon as possible. They're waiting for us. They submitted the question about 40 minutes ago. So, all right. Thank you, folks. The court will be in recess.